Section 6 of the Railway Labor Act, or RLA, governs airline contract negotiations. As noted in a previous video, if either side has requested mediation, the National Mediation Board, or NMB, oversees the negotiations and is in control of the timeline. If the NMB determines that the parties have reached an impasse, meaning that in the NMB's judgment further talks are unlikely to lead toward an agreement, the NMB will proffer or offer binding arbitration to try and resolve the dispute. This proffer of arbitration initiates the process that could lead to a release of the parties to lawful economic self-help. If both sides accept the proffer, a neutral third-party arbitrator, or arbitration board, will make a decision that is final and binding on the union and the company. Should either party decline the proffer of arbitration, a 30-day cooling-off period begins when the board issues a release for self-help. During this period, the status quo obligation remains in effect, and the NMB typically continues its efforts mediating a solution to the parties' outstanding issues. The status quo is a phrase commonly used to describe the terms of employment stated in the contract and established operational and other past practices with respect to such terms in place at the beginning of direct negotiations for an amended agreement. Under the RLA, during contract negotiations, both parties are required to honor the status quo while a contract is in effect and during negotiations for an amended agreement. Until an amended agreement is reached by the parties, or the parties are released to legal self-help, the provisions of the original agreement, along with established operational and other past practices concerning the application of that agreement, are to be maintained. This means that neither party can make unilateral changes in wages, benefits, or working conditions. Under established RLA case law, courts tend to view any company action for which there is an arguable contractual basis as a minor dispute and will usually defer the matter to the party's grievance arbitration process for resolution. Action by employees that disrupts the operation or financially impacts the carrier, on the other hand, are often viewed by the courts as a status quo violation and major dispute warranting intervention. At the end of the cooling-off period, either party is free to engage in self-help. Unions can strike or engage in other job actions, and management can lock out employees, unilaterally impose new contract terms, or hire replacement workers during a strike unless a Presidential Emergency Board, or PEB, is convened. If that happens, the President of the United States, upon the advice of the NMB and the Secretary of Transportation, can appoint an emergency board if the NMB notifies him or her that a strike threatens to interrupt interstate commerce to a degree such as to deprive any section of the country of essential transportation service. The PEB, usually composed of 3 highly experienced labor arbitrators, has 30 days to investigate the dispute and issue recommendations to resolve the open issues, but neither party is required to accept them. The status quo continues during the Emergency Board's investigation and for another 30-day cooling-off period after the President receives its report. Then, both parties can exercise self-help unless Congress intervenes and legislatively mandates a settlement. When this has happened in the past, Congress has generally adopted the PEB's recommendations. This concludes our educational series on the Railway Labor Act. To learn more, visit our MEC website.